Well, good morning, everyone. This is George Spees with the Pennsylvania Office of Open Records. I'd like to welcome you to this morning's webinar, where we're going to spend the next hour or so talking about basics of the right to know law. A couple preliminary things for the good of the order here. The webinar is set up such that there's this PowerPoint, which you should see on your screen right now, with me talking in the background. If for future reference or perhaps some internal training, you'd like a copy of the PowerPoint, it is available on our website on the training page. You'll find a tab for the PowerPoints. You can scroll down and you'll find all of the PowerPoints that we use for these webinars, and along with a wealth of other resources that you can avail yourself to. This session is being recorded. Pardon me. And if by chance you'd want a copy of it, you can send an email into the office or call, and they should be able to set up a link that would give you access to our internal system and the file of this recording. So you can do that. Another option would be to send in a flash drive with a note and a self-addressed stamped return envelope, and they can also make a copy for you. So either method would be successful if you'd want a copy of the recording. During the presentation, if you have questions, you can type them in the meeting chat feature, and I'll do my best to answer the questions as we're going through the session. A couple of things, though, to make that successful. First is, please remember we're talking about basics of the right to know law. So keep your questions on topic, on point. The other thing that I have to ask is that you try to keep them as brief as possible. It's just awkward for me to sit here and occasionally have to read a couple paragraphs that some folks feel compelled to type in while everyone else is waiting patiently. If it looks like your question is dealing with an unusually complex situation or something unique to you, we'll do one of two things. We'll either wait until the end of the presentation and I'll come back and do my best to address it and get you steered in the right direction, or I'll suggest that you contact the office directly, or a phone call where there are staff available to help respond to your questions, or it's possible that they would put you in touch with me and we'd have that conversation offline, and I'll do my best to try and get you steered in the right direction. Okay, so all of that out of the way, let's go ahead and jump into the presentation. Why is the right to know law important? It's in Pennsylvania. It's also known as the the open records law. So those two phrases are interchangeable. But I think it boils down to access, transparency, and basically good government. The premise of the right to know law is that the public has the right to access public records. And that in itself is a very foundational statement that I think can also help people on the agency side of the equation deal with issues when they receive a request or a situation that may not be perfectly clear. Because admittedly, there seems to be, still after 13 years, there seems to be a lot of misunderstanding about just what the right to know law entails. So break it down to its most foundational perspective, and it's giving the public access to public records. I could tell you story after story of people or agencies misunderstanding this, and for instance, having the belief that the right to know law is some form of government Google, where they can simply write out questions on an email or a right to know form, submit it, and it's government's job to run around and come up with answers. That's not the case. We're limiting our search for public records here. And interestingly, that becomes an exercise in itself when determining what is and what is not a public record. And we'll be talking about that in detail here throughout this presentation. But for a starting point for the agency, it's important to remember that as far as the right to know law is concerned, every record that you have is presumed to be a public record unless you can make a legal and factual case that it should be withheld from public domain, that it is not a public record. Now, at face value, that sounds rather daunting. And, people, they first encounter this law, they get their first right to know request, and their immediate reaction is, oh my gosh, everything in the office is going to end up on the front page of the paper tomorrow or on somebody's Facebook page or whatever. There is a good chance that if you receive a right to know request for a record that you're somewhat uncomfortable with releasing out into the public domain, there is a very good chance that there is some tool available, either within the right to know law or perhaps another law, that would determine that this is not public and we do not have to give it out. But you bear that burden legally. You have to make your legal case first to the requester, and then if an appeal is filed, even more importantly, to an appeals officer as to why this record should not be released into the public domain. Otherwise, it is a public record as far as the right to know law is concerned. So the burden, the legal and factual burden, is on the agency. And when I use the term agency, that's somewhat generic. Yes, it could be a Commonwealth agency or commission or board or whatever, but also we're talking about local government, so cities, boroughs, townships, authorities, school districts, and the like. The jurisdiction of the right to know law is fairly broad. So when I use that term agency, it's being used generically for the benefit of everyone attending today. Another point that I feel it's important to make here as we're getting started is the fact that the right to know law is not a confidentiality law. Okay, so what do I mean by that? Well, first offhand, the right to know law does not require that you withhold records. You're going to find that within the law, it gives agencies the discretion to withhold records if they, in fact, are able to meet their legal burden. But even though a record may clearly fall within the exemptions that are included in the right to know law that allow you to withhold records, the law does give you the discretion to not invoke those exemptions and release the record. Okay, so sometimes people will call and say, can I release this record under the right to know law? And the immediate answer is yes, you can. Now, if the record falls within one of the exemptions, and we'll talk about what an exemption is here later, you still, even though that exemption clearly says you can withhold this record, it is not saying you must withhold this record. So you see the logic there. You can release the record even though it clearly falls under one of the exemptions. Where you have to be careful is when we're looking at other laws that might preempt or trump the right to know law, where they say you cannot release the record. And I'll go through that process here as we go through the presentation. The other thing that I think is important to bring out related to this slide is that you can give out public records, meaning there's nothing in the right to know law that mandates you have to follow the right to know law in order to give out an otherwise public record. Let's say it's budget time and you've got a stack of budgets available within your administrative office, and I come in as a resident or a requester and say, can I have a copy of the budget, please? There's nothing in the right to know law that prevents you from simply giving me a copy of the budget. No mention of the right to know law, no right to know requests. You simply hand me a copy of the budget and I walk out the door a happy citizen. You can require right-to-know requests in order to give out a public record if you want to. The right-to-know law gives you that discretion. But understand, it's not a requirement that you have a right-to-know request in order to give out a public record. And many agencies will use their websites as business platforms. What they'll do is basically take a look at right-to-know requests and identify trends in areas where the public is seeking specific types of records. And then they'll turn around and put those records on their websites so that next time they receive a right-to-know request for a particular record, it's a perfectly legal response to say, that record is on our website. Here's the link to the website. And that's all you have to do. And what we've been told and what we've confirmed is that hits on the website start going up and right-to-know requests start going down. So in the long term, it saves the agency a lot of work by being proactive and putting commonly requested business documents on your websites, such as budgets, contracts, salary information for staff, purchasing documents, and the like. It seems to be an expectation now with people and their government where it's much easier for them to sit in the comfort of their family room, get on their laptop, search your website for the information and the records that they need, rather than having to come down face-to-face to the offices, submit a right-to-know request, and potentially wait 35 days before they get the record that they need. Okay, so maybe this is something that you'd want to consider. Use your website as a business platform. Put as many public records on there as you can. Keep them up to date, keep them organized in such a way that they're easy to find. And you'll find that a little bit of work up front probably will save you a lot of work in the long run. Okay, I'll get off my soapbox now, and let's talk about some other aspects of this law. Presuming you're here because, either you're a citizen wanting to find out about the law, but the majority of you are representing agencies, there are some things that you have to do. The first is that you appoint an agency open records officer, what we call an ARO. Okay, this is the person responsible for receiving, processing, and responding to right-to-know requests. They're also commonly referred to as right-to-know officers. Same thing, no difference. An agency can have more than one ARO if they choose to. For instance, last count, I believe the city of Philadelphia has 40 AROs, just given the size of the organization and the scope of programs that they administer. But for instance, you can have one ARO that covers everything, soup to nuts. Then you go 3 miles down the road to the next borough, and they may have one ARO that covers just the administrative side of office operations, and then a second ARO for the police department. Okay, there's no limit on how you can set this up, restrictions, other than it needs to be either an employee or an elected official of the agency. There's no requirement that this person be of a certain level within the organization. There's no requirement that the person be sworn in or voted on by a board or whatever, but you can set up whatever approval process for your AROs that you want to. Here at the Office of Open Records, we regard it as simply a work assignment, but you can do whatever you need to. You can come up with your own local rules for administering your right-to-know program, as long as they're not in conflict with the right-to-know law, and as long as they're not in conflict with any rules put out by the Office of Open Records. I'll give you some quick examples as far as local rules. There is language in the right-to-know law that says an agency may accept anonymous requests. Well, in Pennsylvania, there's this other law called the Statutory Construction Act that kind of defines what certain words mean. And because that word may is in the right-to-know law, it also means may not. So as a local rule, an agency could establish a practice or pass a policy that says, we will not accept anonymous requests. We will only accept requests where the person is identifying themselves. And we have repeatedly supported that position on appeal because of that language in the law. So you'll find as you look at the language of the right to know law that it affords agencies a fair degree of discretion in how they administer their own open records programs. You can also come up with your own form, and many agencies do. They like to have their seal at the top, maybe contact information for the arrow. Any of those special rules that they may have passed locally could be on the form. But you must also accept the uniform request form, or what is commonly known as the state form. You'll find it on our website. There's nothing necessarily special about it. Some agencies will simply link to that, and that's acceptable. So you might want to take a look at that, but you're more than welcome to come up with your own form. Just please make sure that it's representing your agency and doesn't in some way confuse the requester to think that they're dealing directly with the Office of Open Records. We've had a couple agencies that use our seal at the top, and that's led to confusion in the long run. Okay, and then finally, we ask that you provide us here at the Office of Open Records with the name and contact information for your arrows. On our website, there's also a database of arrows statewide, the majority of which are filled with a connection that we have to the Department of Community and Economic Development's MUNSTAT system, municipal government. However, we recognize that people move on, they retire, they get promoted, whatever. So it's important that we keep this database up to date. It's used, sometimes people will contact us and say, hey, I went to XYZ Township's website. I don't see any information on who their arrow is. Can you help me out? And we'll steer them to the database. Or if an appeal is filed, we refer to the database, and that is our point of contact. So it's important that this be kept accurate. So maybe one of the takeaways from today is take a look at our database, make sure your records are up to date. If not, there's a form that you can fill out, email it to us, we verify it, and then we update the database. Okay, so it'd be really helpful. Okay, as far as postings go, yeah, you're required to have some postings. First off, in your physical building, and if you have a website, you need to have these postings there. And the purpose is essentially to educate the requester. And my experience has been the more you can educate the requester by letting them know what the process looks like with a minimal amount of surprises, smoother the transaction is going to go, the easier your job is going to be. So look at it from the perspective of the requester. I don't know anything about the right to know law. I just need this record. So what do I need to do to get it? All right. So the more information you can put out there, the better. First, you have to have contact information for the arrow. Got this right to know request. Who do I give it to? Then you need to have information about the applicable appeals office. And in 95% of the cases, that's going to be the Office of Open Records. You can give them the URL for our website, the website address, because most of what we do online, and people can file appeals directly on our website. We prefer that. Then you need to have a form available so that if they don't have one, you can give them a form for filing a right to know request, if in fact that's necessary. And then you need to list any of those local regulations, policies, or procedures that you may have come up with. It helps to let the person know what the playing field looks like before they ever enter the game. Okay, the fewer surprises, the better, and the smoother everything's going to go. There are some things that you cannot do related to the right to know law. And the first is that you cannot limit the number of records or number of requests that a person submits within a specified time frame. Pardon me. You can't say, ma'am, I'm sorry, you've already filed 3 right to know requests this week. That's all we allow. If she's inclined to file a dozen requests this week, she can do that. Now, let me go off script a little bit and just, acknowledge that for the most part, people file right to know requests because they have a legitimate need for records. But there are a handful of people out there who have weaponized the right to know law. For whatever reason, the relationship between that agency and that citizen has broken down. And they've decided they're going to be a pain in the neck. And one of the ways they're going to be a pain in the neck is to file a lot of frivolous right to know requests. Okay, there are a number of things you can do. I would recommend that you sit through the webinar that we do on payment issues and the right to know law, for the simple fact that most people are willing to pay a nominal fee to obtain public records. People who are misusing the right to know law usually aren't willing to pay any money to be a pain in the neck. Okay, so you kind of see where we're headed here. So sit in or sit through that webinar, and I think that would be a valuable tool for you. The other thing that you cannot do is compel a person to tell you why they are filing a right to know request. Okay, you can't deny a request based on the reason or what you think that reason might be. And this kind of goes back to my other comment about people misusing the law. Sometimes people will file a right to know request just to see you work. And obviously, back to that other webinar that I was mentioning about payment issues, and I think that would be a big help to you. But when push comes to shove, you cannot force a person to tell you why they are filing a right to know request. Okay. I like to portray the right to know process as an obstacle course. The start is basically receiving the request. Okay, that begins the process, obviously. Then you've got some deadlines that you need to be aware of. And those deadlines are important. They're, to paraphrase, they're written in stone. There's no wiggle room on the majority of deadlines related to the right to know law, because it is a legal process that must be followed and is demanded by the courts. Then this course, this obstacle course, it has two hurdles on it. And before you get to the second hurdle, there are three hoops that you need to jump through. So that's kind of gonna be what I describe here with the next couple slides in describing this process of making your way through the right to know law. So let's take a look at it. First is receiving a request. When you receive a request, the arrow needs to note the date that they receive it, because immediately the first deadline kicks in. That deadline is that you have 5 of your business days to provide an initial response. Now, if you receive the right to know request today, tomorrow is your first business day. Okay, because what if you got the request at 4:59 p.m.? Not really fair to expect you to burn a whole business day. So tomorrow would be your first business day. Now, there are some agencies that are not on a Monday through Friday schedule. You go up to the northern tier of Pennsylvania, many townships, they may only be open 2 days a week. So the 5 business days would be you receive the request today, Thursday, Friday, presuming those are the days they're open, would be your first week. Then you go to week 2, Thursday, Friday. Then you go to week 3, Thursday. Close of business, week 3, Thursday, would be your 5 business days. Okay, now what if you're a police department, 24/7 operation? Well, it's those days that you are open for public access. Usually it's Monday through Friday. If by chance you're closed for a holiday, that's not a business day. If there's a weather emergency, that's not a business day, okay? Maintain a copy of the request until, and there's some corresponding laws here that you need to be aware of. The right to know law says 30 days or until all appeals have been exhausted. Okay, so if the request is granted, and you don't receive an appeal, then 30 days works out fine. If an appeal is filed, you want to hold on to everything. And let's say this appeal continues to go all the way up through the Pennsylvania Supreme Court. Well, that can take years. So you want to make sure that you keep everything on file until all appeals have been exhausted. Now, there's another law that I'd suggest you take a look at for municipalities, and that's the Pennsylvania Municipal Records Act. It doesn't necessarily apply to school districts or authorities, but most other agencies would fall under this. And that recommends that you hold on to all right-to-know materials for 2 years. Okay, and that's what I would recommend. For further questions on the Pennsylvania Municipal Records Act, you'll want to go to the Pennsylvania Historical and Museum Commission, their Bureau of Archives and History, in the State Record Center. They're a really good crew over there, very knowledgeable, very helpful. And go to their website first, because that's an excellent resource where you can get all the skinny on how long you should hold on to really all the records that your municipality deals with. Currently, there's nothing comparable for school districts, but maybe at some point, either the Department of Education at the federal level or the state level will come out with something that will provide some useful guidance there. Okay, now, let's say that for a number of reasons, you're not able to provide the initial response within the 5 business day window, within that initial deadline. The right-to-know law allows the agency to unilaterally invoke a 30 calendar day extension. Calendar day would include Saturday, Sunday. It would include a holiday. It would include a weather emergency day. Okay, it's simply 30 days you count out on the calendar that are tacked on to the end of the 5 business days. But in order for the extension to be valid, there are conditions that need to be met. First, you need to take the extension within the 5 business day window. You can't wait until the 6th business day, suddenly realize, oh, I forgot about this right to know request. Well, I'll just take an extension. Unfortunately, you've already defaulted once the 5 business days have expired. Okay, you've done what's legally known as a deemed denial by missing that deadline. So you take it within the 5 business day window. You do it in writing. And if someone has submitted the right to know request, say by email, well, you can respond back by email because that is a written response. You need to provide a reason as to why you're taking the response. And the reasons that you can use are actually listed in Section 902 of the law. There's 6 reasons there. One may be we keep these records off-site, and it's going to take longer than 5 business days for us to look at them. Or we want our solicitor to review them to make sure we're not giving out anything we're not supposed to. So we need a legal review. And there are other reasons that make perfect sense as to why you would take an extension. Just please don't get into the habit of automatically taking an extension, whether it's needed or not. Okay, because that really upsets people, and we see a lot of complaints about that. Next, you need to provide a date as to when the requester can expect to get their response. Usually, it's on the 30th day of the extension. And then you need to give an estimate of any costs that the requester can expect to incur. And it is just an estimate. It's not a hard quote. It could be a little high, a little low. You settle up when it comes time to actually provide the records that you're granting to the individual. So like I said earlier, you've got the 5 business days, and then you have the 30 calendar days tacked on to the end of the 5 business days. And all this is outlined in Section 902(b)(2) of the Right-to-Know Law. And by the way, the law itself is accessible on our website. It's not like a long law per se. And for the most part, it's written in common English that us yeomen can understand. Okay, so feel free to download it for free and give the law a look-see, and hopefully you'll gain an even further understanding. Excuse me. Okay, so now we've come up on this first hurdle. What's that all about? Well, we need to answer the question, is the individual requesting a record? Okay, well, that seems fairly basic. But if you go to the definition section of the Right to Know law, and this is just an aside, I do a lot of research on laws, and one of the things that I have found very helpful is always go to the definition section, because if there is a lack of clarity, some sort of vagueness about a law's meaning, there is a very good chance that you can find that clarity in the definition section. So we go to the Right to Know law, and sure enough, there's a definition of what a record is. Any information, regardless of its physical form or character, that documents a transaction or activity of an agency and is, et cetera, et cetera. Okay, the key phrase is highlighted here. Documents a transaction or activity of the agency. What does that mean? Well, basically it means that the record or the communication has to be about what the township does, what the borough, what the city, what the school district does, okay? And you're thinking, well, that seems rather obvious, but think about it. All day long, we generate communications, messages that do not rise to the definition of a record. Understand a new restaurant's opened up downtown. You want to meet for lunch tomorrow? Or, hey, what do you think of the trades that the Eagles are making and their chances of success this fall? Or, I'm picking up a gallon of milk on the way home. Okay, all fairly common communications, but yet have nothing to do with documenting a transaction or activity of an agency. Thus, they are not records. They're off the obstacle course. They don't make it over the first hurdle. And we don't have to worry about communications like that of a personal nature being released through the Right to Know law. They're not considered responsive records because they don't even meet the definition of a record. Okay, now let me also give you another example here. Let's say that I'm, a township supervisor, but I'm at home in my family room and I'm on my personal computer and I'm using my personal Gmail account. But I send a message to my colleagues on the board. I understand at tomorrow night's meeting, this proposal is coming up to revise an ordinance. I have some issues with it, and honestly, I'm leaning against voting for the proposal, but why don't you guys tell me what you think? Okay, and I send that out, and it results in, an email conversation with my colleagues. The fact that I'm in my family room on my personal computer, on my personal Gmail account, has no bearing on whether it's a public record or not, or whether it's a record per se, because you look at the content of the message, not how it was sent or where the message is being stored. And that could include, personal cell phones. Now, there is nothing illegal or wrong about using personal devices. Just understand that there is a legal decision, actually several legal decisions, that basically conclude you cannot use personal devices and personal accounts to hide the public's business. It's going to come down to, does your communication document a transaction or activity of the agency? If it does, then it makes it over the first hurdle as a record and needs to be considered as perhaps a responsive record to be released for the Right to Know request. Just depends on, what they're asking for. Okay, so keep that in mind. Personal devices, personal accounts, have to look at, is it documenting a transaction or activity of the agency? My recommendation would be, if there's any way you can separate personal messages and personal devices from whatever resources your agency can provide to you to conduct agency business, that's good. Okay, the law doesn't require that, but just from my experience, the better you can separate it, the easier it makes the process, and the less potential conflict results. Okay, moving right along. Next, we're coming up on the second hurdle, where now we have to answer the question, is it a public record? Note the distinction. First hurdle, is it a record? Now, is it a public record? So we have the first hoop that we have to jump through. And that involves the right to know law itself, and we have to answer the question, are there any exemptions that apply? And if so, are we going to invoke those exemptions? Now, you go to Section 708B of the Right to Know Law, and you'll find 30 exemptions listed. An exemption is simply several paragraphs that result in a definition of a type of record that can be withheld if the record falls within that definition. And it covers an extremely broad spectrum of records. Everything from, for instance, if by releasing this record, it would put someone in physical harm, or any record that reflects discipline against a public employee, or any record that by releasing it would give out sensitive information about a minor, anyone receiving social services, any record that is part of a criminal investigation. Okay, so those are just some brief examples, but take a look at it and you'll find that, number one, yes, an incredibly broad spectrum of records are protected by the right to know law. And two, if a red flag goes off when you look at this right to know request, there's a very good chance that you'll find the right to know law gives you the tools to withhold that record and helps you to make your legal and factual case as to why that record should be withheld. Okay, so take a look at Section 708B and those exemptions. And remember, like I was talking about earlier, these exemptions are discretionary. That's why we say, are you going to invoke them? Because you don't have to if you don't want to. The right to know law gives you that choice. Okay, so that's the first hoop that we make it through. And if there are no exemptions, or if there is an exemption, we're choosing not to invoke it, we make it through the first hoop. So now we come up on the second hoop. And this one's interesting because we have to answer the question, are there any federal or state statutes or a judge's order that make these records non-public, that say these records are confidential? Usually, if there is another law, it does not give you the same discretion that the right to know law does. If it says the law is confidential, or if it says the record is confidential, it is, and you have no choice to release it. I'll give you some quick examples. Police departments deal with a law called CRIA, the Criminal History Records Information Act, that define a broad spectrum of records that typically a police department will deal with. And the law says that you can only share these with other licensed police departments. You cannot release these to the public under penalty of law. School districts deal with a law called FERPA, the Family Educational Rights and Privacy Act. FERPA says that individual educational records cannot be released to the public. All right, so those laws say you cannot. They don't say may not, they say cannot. All right, and if there is another law or a judge's order that says the record is confidential, that trumps the right to know law and any discretion that you otherwise may have. So let's say you're denying a request based on confidentiality language in another law. That's how you would meet your legal burden, by citing the appropriate provisions of those other laws. And those are also valuable tools that you would use to withhold a record from public release. It's just that you have to meet your legal burden. So you cite, like I said, the appropriate provisions of those other laws as your legal basis. If there is another law, then you're off the obstacle course. Okay, you haven't made it through that second hoop. But if there isn't another law, then you go through the hoop, and now we come to the third hoop. Okay, and here we have to answer the question, is there any chance this record is protected by privilege? And typically, we're talking about attorney-client privilege here. Most agencies will have legal counsel available to provide guidance. It could be a local solicitor. It could be, chief counsel for a state agency or whatever. Well, any communication between an attorney and their client of a sensitive nature is usually protected by attorney-client privilege. So if there is, let's say, emails from a solicitor going back and forth to a borough council or the mayor, whatever, there is a very good chance that those communications are protected by attorney-client privilege. And attorney-client privilege in Pennsylvania are considered part of the rules of evidence. It's supported by statute. And if you go to Section 305 of the Right to Know Law, there's a reference to it there. That would provide a basis for denying access to those records. If there's any question, I would suggest having a conversation with your counsel, with your solicitor, and let them decide as to whether or not the records are protected by attorney-client privilege. Okay, something's popped up here. You want to be unmuted at the end to discuss CREA. Yeah, we can see if I can work that out. Otherwise, we may have a conversation offline, but yeah, I'll try and help you out there. We do, just for the good of the order here, since everyone can see that, we do also do a webinar on the Right to Know Law for law enforcement, where we discuss CREA in greater detail. But yeah, I'm more than happy to have a discussion here at the end of the webinar, and I'll see if it's possible to unmute you. Okay, moving on here. If we make it through the third hoop, then we can jump over the second hurdle. And at that point, we're saying it is a public record and can be released into the public domain. We've met all of the conditions to determine that this record is in fact public, and it is considered responsive to the right to know request that we're currently processing. Okay, so let's assume that we're releasing the records. Well, then we need to take a look at the payment side of the right to know law. And I'm just going to discuss that briefly here. There's a section of the right to know law that you need to be aware of, Section 701. And it basically says that the agency is only required to provide the record in the medium in which it exists. Okay, now I'm paraphrasing there a little bit, but what does that mean? Well, we're talking about hard copy versus electronic. Real quick example here. Let's say that our agency issues building permits. So everything is paper driven. We receive the requests in the mail with all the associated documents. They go to our codes department, they do their thing, and they issue a building permit, which is a paper document. So we maintain a copy here in the office. It's kept in a file folder, in a file cabinet. Okay, everything is paper driven, nothing really electronic to speak of. But we receive a right to know request through email, and the person is requesting a copy of the building permit, and they'd like it sent to them electronically. Well, based on the language in Section 701, because there is no electronic record of the building permit, the agency does not scan it in, because that would be converting it from hard copy medium to electronic medium. Follow my logic there. There is no requirement that an agency scan in records so that they can email them, because that's converting it from one medium to another, and that's covered in Section 701. Okay? Now, you can scan them in if you want to, but you cannot charge for electronic records. No charge for electronic records, whether they already exist in electronic medium or if you have to scan them, or if you choose to scan them in. Now, under the right to know law, there's also the option of what we call inspection. A person can request copies or they can request to inspect the originals, which means coming into the office. In that instance, the agency is in the driver's seat. The agency determines when during normal business hours it's convenient for this person to come in and look at the records. And the agency can supervise the inspection to make sure nobody, steals or alters or destroys any records. And you can determine, what's a reasonable period of time, so forth and so on. Okay, you cannot charge for labor. You cannot charge for redaction, which is when you black out certain sensitive data elements, and you cannot charge for legal review or solicitor to review, what are considered responsive records before you send them out. You can only charge, that's just considered, the cost of doing business for government. You can only charge for actual costs like postage or something that can be documented through receipt. Like if you have to go out and have a blueprint copy made, okay? And they charge you, maybe Kinko's charges you $10 a sheet, so you can pass on that actual cost to the requester. Just let them know to expect a cost so that they're not taken by surprise when they receive that invoice from you. Yeah, like I said, no surprises. There is absolutely nothing in the right to know law that prevents you from having a dialogue with the requester and vice versa. The more you speak to each other, the more you communicate, the more information that is exchanged, the easier the process. So the fewer surprises, the more satisfied your resident is going to be. Seamless the entire process is going to be. So there's absolutely nothing wrong. You get a right to know request, something isn't clear, or maybe just as a matter of practice, you know that there's going to be a cost, so you pick up the phone or send an email, say, by the way, we think your response is going to cost about $30. Are you okay with us proceeding? Okay, you save yourself a lot of work if they're going to balk at that. Plus, like I said, no surprises, they're going to be satisfied. Okay, now, typically there's a mutual exchange. Here's your records, here's your money. But if push comes to shove, the right to know law says that records are provided upon payment. That means they pay first, then they get their records. Now, you work out whatever system works for you. But if push comes to shove, you can do that. There's also a provision within the right to know law that says you can demand payment up front if it looks like the response is going to exceed $100. Okay, so you do a quick estimate. It's like, well, this is a really big response. It's going to exceed $100. I like to refer to it as a security deposit because it ensures that you have cash in hand before you begin processing a really big response, and there's no chance of you getting stiffed for all the paper that you're going to generate as a result. There's also a provision within the right to know law, section 905, called record discard. There, the scenario would be that we're granting your request, and through discussion, it's agreed that they're going to come down to the office or Borough Hall or wherever and pick up the records, and they'll pay for them then. Well, what if they don't show up? The right to know law gives you 60 days to hold on to them. Then, after the 60 days, you can destroy the records. If there is a cost, that cost, though, doesn't go away. And we do another webinar called Right to Know Law and Payment Issues, which I referred to earlier, where you might want to sit through that to get an idea on how some of these costs are generated and what it means when there are outstanding costs from a requester and their account is in arrears, they haven't settled up, because that can be a real problem for the requester, not necessarily for the agency. And if by chance there are outstanding fees, the agency can deny further requests until that account is settled up. Okay, let me repeat that. If a right to know request, if the response has not been paid for and there is a debt, the agency does not have to process any further right to know requests from that individual. Now, make sure all your I's are dotted and your T's are crossed related to this whole outstanding thing. Because if you deny a request for non-payment, the person can file an appeal. All right. But you can, for instance, all the decisions we've ever rendered from our agency, you can actually find them on our website in the searchable database. You can put the word fees in there, and all these decisions related to non-payment will come up. And you'll find that in the majority of cases, the great majority of cases, the appeals officer has agreed with the agency on the non-payment issue. But have everything documented relative to your communication, how you calculated the debt, what, if any, discussions there were, and so forth and so on. Okay, question has popped up. What is the retention schedule for right to know records? Well, we did cover that in an earlier slide. It's either 30 days or until all appeals have been exhausted, or you might want to take a look at the Municipal Records Act, which recommends 2 years, which would be my recommendation. But Janelle, go back and take a look at that slide. That'll answer your question. Okay, what if this person, the request, didn't make it through the obstacle course and we've decided it's appropriate to deny the request? We have an actual format for a denial letter that we recommend you follow. The first thing you do is describe the records in question, okay? You're thinking, well, that seems rather obvious, but sometimes people aren't absolutely clear in what it is they're looking for. So put it in your own words. We received your request. We believe these are the records that you're seeking. Then you state the legal and factual grounds as to why you are denying it. Why aren't these public records? Are you invoking one of those 30 exemptions? Is there another law that says these records are considered confidential? Does it fall under attorney-client privilege? Think about the process that we went through. This is where the rubber hits the road, folks, because remember, as a right to know officer, you're the person legally responsible for responding to these requests. So this is where you make your legal case that these records fall under this exemption of the right to know law. Then you put the name, title, and signature and the contact information for the arrow, because you're the person responsible. The date of the response, and this is important because now we have another deadline to deal with, which I'll talk about here in a moment. And then the procedure for filing an appeal. And like I said, usually you file the appeal with the Pennsylvania Office of Open Records. You can file it directly on their website, and the person has 15 business days to file said appeal. Okay, so kind of covering that here in this slide. If you deny a request, the person has 15 business days. And now we're talking about Office of Open Records business days, which for the most part is a Monday through Friday calendar. Okay, they can file it on our website. Just give them our website address, but let them know they have the 15 business days. Okay, so that's the information you would include on the denial letter. Now, let me just talk about denials here as we wrap things up. I'm sorry, appeals as we wrap things up. Quick sip of coffee here. So the person files the appeal. Hopefully it's on our website. If not, they can mail it into us. But we immediately look for 4 elements. We need a copy of the original request. We need a copy of the agency's response, provided there is one. The person needs to give us a statement as to why they believe the records are public, and then a second statement as to why they believe in denying the request, the agency was incorrect in their application of the right to know law. All right, if any of these elements aren't included, our first thing is to issue what's called a deficiency order, and we give the person a couple days to correct the deficiency. If they do so and everything's there that we need, the case gets docketed. Now, docketed means that it gets entered into our system. We have a docketing system. It gets assigned to an appeals officer, and it gets assigned a docketing number, which is usually, for instance, it would be something like AP 2022 dash and then a 4-digit code. And then we send out a notification to all the parties, the requester and the agency. This notification will include a copy of all the related records, all that information I was talking about, including the contact information for the appeals officer, instructions, deadlines, and the like. Everything is shared between the parties. There's nothing secret. For instance, an agency can't send the appeals officer an email and saying, we don't want this known to the requester. Everything gets shared back and forth. And the appeals themselves are considered public records. You can file a right to know request for a copy of an appeal. Now, if you're on the agency side of the equation and you receive one of these docketing packages, the best advice I'm going to give you here today is run, do not walk to your solicitor. Let them know that you've received a right to know appeal, because this is a legal process with tight deadlines built into it. And your solicitor is the person who's going to be, the point of contact. That's the person that's going to have to do most of the work. If you're an appeals officer or, just an employee, do not try to respond to an appeal on your own. Because this being a legal process, there are certain forms that need to be used. There's certain language that must be used. You've got these tight deadlines. And we would hate to see you lose an appeal based on a procedural error rather than giving the Office of Open Records to weigh in on the substantive issues of the appeal itself. Okay, so go to your solicitor immediately and give them everything within the packet so that they can get started on the agency's response that they have to do within very tight deadlines. Okay, if the denial is based upon the provisions of CREA, who hears the appeal, district attorney or OOR. Yeah, it is the OOR. If CREA is the basis for the denial, it would still come to the Office of Open Records. Good question. Okay, moving on here with appeals. The product of an appeal is what's called a final determination, which is a legally binding final order issued by our office, usually within 30 days, occasionally within 60 if we ask for an extension. It is published on our website in that searchable database. It's available if you have any of the legal services like Lexis or Westlaw. It looks just like a legal decision that you'd see, coming out of your county court of common pleas. A lot of similarities in its format and the language that's used, the logic that's used. Usually a lot of legal citations within it, but it is a written decision that comes out of our office that determines whether or not the appeal is denied, granted, or sometimes something in between. Now, there is the option of mediation. We have trained mediators on our staff. Let's say that, well, first offhand, when the person files an appeal and they do it on our website, we ask them, would you be interested in mediation at all? And if they indicate that, yes, they would be, our system makes note of that. So that when we send out the docketing packet, there's a description of what mediation is that also goes to the agency. And if they also indicate that they're interested in mediation, then the case gets assigned to a mediator rather than an appeals officer. And there are some times, actually there's a lot of times, where if you can just get the parties talking to each other, and sometimes it's a conference call, usually it's a conference call, and you just get the parties going back and forth and finally having some communication, the situation can be resolved. But if not, let's say that they agree to mediation, but it just isn't going anywhere. Well, the case can be easily withdrawn from mediation and gets assigned to the appeals officer and you start over. Okay, so no harm, no foul. But we just want to let you know that mediation is an available option and it has proved fairly successful. Okay. Now, our decisions can be appealed. So if you're a local agency, or if you're dealing with a local agency, and we issue a decision that you don't like, within 30 calendar days, you can file your appeal with the County Court of Common Pleas. And then they would rule on that. However, the dispute is still between the requester and the agency. Do not list the Office of Open Records as a party to the court appeal. Okay, we're essentially a lower level decision maker. The Pennsylvania Supreme Court has defined us as an independent quasi-judicial tribunal. That means we're not a party to the dispute, rather we are a decision maker in the dispute. But you have to provide us with a copy of your appeal so that we can monitor it as it works its way through the court system. And we may, in fact, weigh in with documents or filings, or even ask to litigate if we believe it's an important point of law. Okay. So that's pretty much the appeal process and the right to know law in a nutshell. Hopefully I've answered any questions that you may have had. If you do have further questions, now's the time to get them in. But I also want to recommend that you take a look at our website. There is a wealth of resources available on the OOR's website. Guides for citizens, guides for agencies. If you're an agency open records officer, there's a 78-page agency open records officer guidebook that provides a lot of forms that you can use, just helpful information. There's a training page on the website with videos that you might want to take a look at or listen to. You can also subscribe to our Twitter feed or an email feed. If you're a real geek about government transparency, we will wake you up every morning, usually around 7 a.m. with a tweet that gives you all the news you need to know about government transparency, all the decisions we issued the day before, any court decisions, training opportunities, and the like. Finally, if you have any questions, on that website, you'll find the office phone number on the screen right now, as well as email accounts that you can submit your questions, and the turnaround time is pretty good. Someone will get back to you because we realize if you're contacting our office, you're probably dealing with a tight deadline. Now, let me see if there's any way I can unlock the muting here. And Mr. Pulaski and I can have a discussion. No guarantees. I'm just kind of checking, seeing what I can do. Let's see, meeting options. And okay, I'm going to allow a mic. Okay, Mr. Pulaski, are you there? Oh, wait a minute. I think I have to save this to make it work. Sorry about that. Aha. Now I'm allowing mic for everybody, but I'm just going to ask.
Okay. Can you hear me now? This is Phil
Yes,
Pulaski.
I can hear you. Go ahead.
Great. Thank you for a wonderful presentation. Very, very, very informative. And
well, thank you.
I know the Office of Open Records has been very helpful. But here's my question. So CREA prevents the release of a broad category of records when you look at the definition of investigative information.
Correct.
We want to give those records out if we were only constrained by the open records law and we had discretion, we would give many of those records out, but we're precluded from doing so by CREA. So here's my question. If we have a situation where a resident or a visitor needs a investigation report, contains information regarding possible criminal activity, and they need it so that they can apply for a PFA in a domestic case. Is there, I've read CREA front to back. I'm an attorney, and I cannot find an exception And I just find it so counterintuitive that
Yeah.
I cannot provide this investigation report, incident report. As you know from the Superior Court cases, it doesn't matter what you call the record. It's substantively what's in the record. And the record that is required for the PFA is clearly contains investigative information. It seems just so counterintuitive that I'm
Yeah.
precluded from giving that record out.
I have two suggestions. First is that you might want to reach out to the Pennsylvania Attorney General's office. They have a very good CREA guide on their website that I referred to, plus they have some staff that might be able to provide better insight. The other thing that I would explore is whether or not you could have direct communication with the court. We've done this in limited cases where because of a legal review, records were provided directly to the judge without ever releasing them to the public per se. So I'm wondering if that avenue isn't possible to provide the investigative materials directly to the court, where the court would then have the option of deciding whether or not they become accessible through the court process or would be held in abeyance by the judge as confidential without ever really directly releasing them to the person seeking the PFA. I don't know if that's possible or not, but it might be worth exploring.
Well, so what we find ourselves in is, again, a counterintuitive position where the way I've been doing it is where I have to tell my resident that, can you have the court order a subpoena ducis tecum to get this record? Go. And well, hang on, but the resident is looking me in the eyes because I'm apologizing as I'm speaking to them and saying, but all the information in this record is mine. So that's my second question. Yeah. Is there an exception when the information that's being provided, in other words, I can redact out the perpetrator's information, but generally speaking, all the information is being provided is coming from the person seeking the record, and they're actually creating the record, and it's the only thing that's in the record is their statements and our taking it. Is there a workaround on that?
Well, that's where I would recommend the discussion with the Attorney General's office, because if you are redacting information of someone being accused of a crime, then the record may not rise to the definition of what would truly be considered an investigatory document.
Now, it contains, so it's not, is it an investigatory document? Because the name of the document's irrelevant. Does it contain investigative information? And the definition of investigative information is so broad that you could land a 747 in it. So I just one last thing on an appeal, when you deny based on CREA, I believe the appeal goes to you, the Office of Open, as opposed to the DA.
Yes.
Right. So I don't know if the Office of Open Records has any influence on the legislative process, but this conundrum created by CREA, and I understand the legislative history, it's designed to protect the identities of sex crime victim and whatnot, perfectly legitimate, but it's so broadly written that while doing good, I think it may be doing quite a bit of harm also.
Well, yeah, as you've discovered, the right to know law, I think, gives you
much better
wiggle room to get through that.
Yep, much better.
Your challenge is CREA, which we really don't have any say on. Again, I think that would fall under the purview of the AG's office. But
I thank you very, very much for a very, very informative presentation.
I'm glad we were able to help out.
Yeah, and every time I call the Office of Open Records, they're just absolutely the best. Very, very helpful.
Glad to hear that. Thanks again.
My pleasure. Bye-bye.
Folks, thank you for your attendance today. I hope we were helpful, and we'll be having another webinar Wednesday, 2 weeks. Thanks again. We're signing off.